Good morning, everyone, and welcome to today's presentation. Today, we are focusing on a seminal judgment pronounced by the Supreme Court of Pakistan, reported as PLD 2020, Supreme Court 269. The judgment discusses the rights of women and their historical perspective. Let us get started. The judgment takes a closer look at how marriage historically transformed women's identity, especially in early modern England and Europe. As eminent lawyer Amy Lois Erickson discusses in her book Women and Property in Early Modern England, women's legal status and property rights were deeply affected by marital laws. William Blackstone's famous commentaries on laws also highlighted this issue, emphasizing that the law considered a married woman as a legally united with her husband. This concept is known as doctrine of Coverture, where a woman's legal existence was essentially suspended when she married. Now, what this exactly means? Well, the femme coverture or married woman was legally incorporated into her husband. She could not sue anyone and could not be sued. She could not sign a contract independently. Her legal identity was absorbed into her husband, which meant that she had very little autonomy under the law, and property wise, all the assets she brought into marriage, like dowry or portion, immediately became the property of her husband. So, marriage was a kind of legal and social merger. This concept was not limited to England. Similar ideas persisted across Europe and America, making women almost invisible legally within the marriage. All of this shows us a startling truth. Marriage for centuries fundamentally altered women's identity, reducing their legal independence and personal agency. It is a powerful reminder how legal structure can shape a societal role and perception of women's rights. So, in effect, the women were civilly dead. They were stripped of their legal personhood. They could not hold any property. Why this happened? Why was it so in the so called civilized world? Let us explore some key moments in the legal and societal history of women in the West. First, Stephanie Coons, in her book The Way We Never Were, highlights how the American families have often been idealized, masking the realities women faced. Then, moving to legislation, the Equal Credit Opportunity Act of 1974 and Sex Discrimination Act of 1975 marked significant steps towards gender equality and financial and legal rights. In terms of literary history, Melissa Homestead sheds light on how women faced hurdles in their lives. The Supreme Court of Illinois in 1867 declared that women could not control her own property without risking the destruction of her marriage. How backward! An incredibly restrictive view. Women's status were precisely similar to unfortunate Negro slaves. They were treated alike. Both were unfortunate. When it comes to banking, it was not until 1960 in the USA and 1975 in the UK that women could open a bank account with her husband's permission. So it was 1960 that women became people in the eye of law. As compared to this, let us start by looking at the concept of financial independence of women in Islam. The Quran clearly states that men shall have the benefit of what they earn and women shall have the benefit of what they earn. So women and men have equal financial autonomy. The Quran explicitly states that men shall have the benefit of what they earn and women shall have the benefit of what they earn. Property given at marriage is the wife's property. It is her absolute property. It cannot be taken back by husband. So we see principles in Islam in 17th century were far more equitable and progressive than those of the West in 19th and 20th century. Gender justice in Islam was conspicuous as compared to dark ages of the West. The judgment also refers to the real world icons in Islam. In this slide, we see examples of two great ladies who have made significant impact in the history and society. Unlike the West, Muslim women have retained their own identities and properties for more than 14th century. So Islamic law allowed them, rather encouraged them to be leaders, scholars and independent individuals. The judgment next considers the principles about marriage in Islam as well as in Pakistan. It refers to the provisions of the Constitution that treats men and women equal and the law of 1939 about the dissolution of Muslim marriages, in which it has been held that if a husband sells his wife's property against her will, it will be cruelty and could be a cause of dissolution of marriage. Equality before law is the golden code in the Islamic teachings. In Qadr Hussein's case, the Federal Shariat Court ruled that gender, color, creed, they cannot be used to deny the fundamental rights of men, women. Against this backdrop, the Supreme Court of Pakistan discussed the facts of the case. In this case, a husband tried to pledge his wife's property in the Nikahnama of one of his relatives. The court noted that his wife never signed or agreed to it, so the court held that her husband had zero right to her property because Articles 23 and 24 of the Constitution of Pakistan protect the rights to hold property regardless of gender. So we see that the case of Muhammad Khurshida is not a dry legal file. It is a modern day reminder that the golden code of equality in Sharia is built into the very constitution of Pakistan. It is a shield against outdated colonial concepts that once tried to make women civilly dead. So, knowledge is your best defense. In the light of law, every one of us has a right to hold and dispose of property in the way we want, subject to restrictions imposed by law, but no one else can dictate us. If you have learned something from this video, then please hit the like button and subscribe to this channel. And if you have a story or a question about property rights, drop it in the comments. I read every single one of them. Thank you very much for watching.